Yes, we are live.
Okay. Um, Good evening, everyone. I am Nitya Jain, the co-founder of Commercial and Financial Law Reporter. And today I am thrilled to welcome you all to Commercial and Financial Law Reporter's quarterly debate series, The Project Discourse. At CFLR, we have always tried to delve into extensive research and argumentation to understand the nuances of a multifaceted topic. And with this vision, we have started the Project Discourse. Project Discourse is an academic debate wherein the experts of the field will dispute and deliberate over an extremely critical yet relevant motion. As COVID has pushed us inside the virtual world, today's motion for the debate will be that this House believes that remote hearings can replace physical hearings in arbitration. With this, I'm extremely glad to introduce you all to our expert panel. Firstly, we have with us Mr. Vyapak Desai, the head of International Dispute Resolution and Investigation at Nishith Desai Associates. Sir has a vast experience in disputes, including treaty disputes, commercial disputes, trade, infrastructure, equity, and much more. He is listed on the panel of arbitrators of SEAC, AIAC, and LCIA. We welcome you, sir. Secondly, we have with us Mr. Ajar, partner at Rub and Rub Associates. Sir is also a renowned international arbitrator and a visiting faculty at leading law schools in India. He is currently pursuing his doctorate in commercial arbitration. We're thrilled to have you, sir. And finally, we have with us Mr. Rohan Batra, who is the partner and co-founder of R&R Law Chambers. Sir handles complex and high-value commercial disputes and is also an advocate on record in Supreme Court of India. Sir, before starting his own law firm, worked as a principal associate in Shardul Merchant Mangal. With this brief introduction, I would now invite Mr. Rohan Batra to take it forward from here. So please.
Thank you, Nitya, for that introduction. And thank you, CFLR, for this opportunity. Before I go down into the topic, let me share my own little experience about how I felt an arbitration proceeding used to be like. It used to start with the appointment of arbitrators, that back and forth email exchange used to happen. After that, timelines used to be set for filing of the pleadings, and both parties used to file bulky, voluminous pleadings as well as documents on each other. But this was always the mundane part for me. What I enjoyed more was the action which you get when you go down a physical hearing and watch either a great counsel argue, or maybe you're lucky and you get that opportunity. The adrenaline rush that you get makes you feel that you've done a day's job. But in this new normal, things are of course different. We've already started moving on to the online platform. Just like this webinar or discussion is happening online across the globe as we speak today, many arbitrations are gradually moving to remote hearing. But that begs the question, what happens to things like the dynamics which play out during the course of a physical hearing? That file or case law that you need to quickly pass on to your senior for who is arguing the matter, or that page number that you have to quickly open up while arguing so that you can pinpoint that relevant paragraph to the judge. And there are other concerns like the connect with the judge, not being able to read the body language or the non-verbal cues of any witness. But the truth is, we've already made that shift. And there are certain advantages as well, like saving of time, saving of earlier people used to fly out to just have few days hearings. That used to be a huge amount of cost for the client. Those concerns are being addressed, but there are new sets of challenges on the way, which takes us to the topic of the debate. Can remote hearings really replace our old traditional physical hearings? And for this, we have two esteemed panelists who actually don't require any introduction. Mr. Vyapak Desai is going to be for the motion. That is, he's for the motion of replacing the physical hearings with remote hearings. And Mr. Ajar is going to be against this motion. And to put things in perspective, we have divided this debate into three broad themes. Number one, the legal framework. Is there really a bar under the Indian law as to having online hearings, or is physical hearing a necessity for both oral arguments as well as cross-examination? Theme number two is about replaceability or substituting hearings for oral examination or cross-examination of witnesses. And finally, the third theme is about, can we have oral arguments or advocacy through a remote screen compared to the traditional physical hearing? At each juncture, both panelists will represent for and against the motion. And on the first theme itself, Mr. Vyapak Desai will be beginning with his side of arguments for the motion. My role as a moderator will be at each stage and at each level to create some tangible takeaway for everyone. At the end, we will give both sides equal opportunity to present them, to step in and give a short summary and an analysis of both sides of the arguments and perhaps where we stand today. After this discussion, we will leave the floor open to a short question and answer round for all our participants and who are eager to ask questions to our panelists. Without further ado, I open this panel discussion with the first question to you, Mr. Desai, is there a bar under the legal framework of the Indian Arbitration Act which disallows remote hearings for all sorts of things? Let's say for final arguments or a Section 17 motion, or for that matter, oral evidence. I leave the floor open to you.
Sure. Thanks, Rohan, for this kind introduction, and thank you, CFLR, to bring up this topic as a debate, because I'm sure, like every other issue, there are pros and cons to this issue as well. My duty today is to represent the for the motion arguments, so I'll try and do that to my best endeavors. So I think let me start with, before going into the legal framework aspect, right? I think the world which we are living in, right? We always used to say that, you know, the change is the only constant. I guess now the caption is that disruption is the only constant. I think it's no longer incremental change. It's all about disruption. What happened to, you know, media industry with OTT platforms? What happened to physical cash systems and economy with the advent of right from credit cards to payment systems like Paytm or PhonePe and others, and possibly what happened with Uber and Ola to the physical, travel industry. I think all of them went through a big disruption, and some of the disadvantages or some of the concerns that we possibly would be talking today were pretty much, or similar concerns were raised in those industries as well. I think COVID has given a great opportunity for the judicial system to disrupt, particularly a system like ADR, where you have much more flexibility than a court system. And when it comes to arbitration, I think this is a fantastic opportunity where jurisdictions don't matter anymore. You can't take advantage of being in Delhi or Bombay or New York or Singapore just because you are there, that you get that advantage. I think virtual hearing and case management can throw up great opportunities to include a large part of legal advice, which otherwise was not accessible because of the issues of, travel or issues of different jurisdictions, time zones, and whatsoever. So I think to start with, in my view, it was time for this aspect of industry also to go through disruption, and every disruption brings concerns, but which can easily be overcome. Second, on the legal framework, and which is your pertinent question for this theme, I think uh, the very basis of arbitration clearly answers that there cannot be any challenge uh, so far as arbitration is concerned, because the basis of arbitration is party autonomy and flexibility. So long as parties agree, there cannot be anything which can come, in way, particularly for the process of arbitration. Whether you look at Section 18, particularly Section 19, which in fact gives autonomy and some kind of a right to the parties to agree to the procedure of arbitration, not even to the tribunals, not even to the institutions if it is an institution arbitration, or not even to law or otherwise, depending upon where it is seated. So in my view, parties' autonomy is paramount, and so long as parties agree, there cannot be any hurdle, or there cannot be any issue in adopting any procedure, be it be virtual or otherwise. Yes, it may require some level of agreement either at the stage of entering into an agreement, or maybe at the time of when reference is admitted by the tribunal, or maybe under the institution rules. But I really don't see a reason why this cannot be, taken care of. One may argue that then if parties don't agree, you cannot have virtual hearing. Even that may not be true, because at the end of the day, this is a procedure. Anything which allows efficiency and effectiveness of the procedure, I think, as the time goes, the legal framework and the institutional framework and the every other aspect of arbitration would take care of this process to allow the flexibility of having the virtual hearing. So I really don't see any any kind of impediment so far as the legal framework is concerned. Uh, the other aspect is, somebody may argue that, look, at the end of the day, when it comes to arbitration, seat is paramount, and in a virtual hearing there is no seat. So how would you determine where the arbitration took place? I think that at the start that argument is flawed, because seat was always a concept where you don't have to connect it to the physical place at which the arbitration is actually held. You put into your agreement that seat is Singapore. Arbitration can easily be having a venue or can be held in Mumbai or Hong Kong or wherever you want. So I think it was always a legal concept. You can always fix a seat or place for the legal purposes under the agreement, or it can be determined based on the other factors to the agreement by the tribunal. But virtual hearing or the aspects that it is held virtually would definitely not have any impact on determination of seat. So having said that, I think in my view, two arguments which clearly are in favor for the legal framework to support virtual hearings. One is party autonomy, which can take care of everything. Two, the legal framework everywhere allows parties to decide how the process would be followed. And three, even for the seat aspect, it is purely based on the legal framework of the clause, that where you assign the seat of the arbitration rather than where you actually hold the arbitration virtually or otherwise. So I really don't see a problem so far as legal framework is concerned.
Thank you, Mr. Desai. So if I were to summarize what you just said, the 2 points of arguments which suggest that there is no bar in the legal framework is one, party autonomy, which allows the flexibility to the parties to decide how they want to conduct the hearing. And what I was going to be my question to you is about the seat. You've sort of said that seat has to be, as a concept, de-associated from the physical hearing or the virtual hearing, so to speak. And therefore, now this takes me to our other panelist, Mr. Rab. How would you like to respond to these two arguments, which have been made in favor of supporting virtual hearings under the regime, under the Indian Regime Act? And do you feel that there is a legal, especially in a case where parties do not agree on having virtual hearings for any reason whatsoever?
Thank you, thank you, Rohan. First up, I'd like to clarify where I stand. And the fact of the matter is that as much as it appears that I'm opposed to the motion, I'm not in fact opposed to the motion. All I'm saying is virtual hearings cannot replace physical hearings yet, right? I mean, there are still so many aspects to be worked out before we can jump the ship and say, let's all go in, virtual is the new arbitration 2.0 reloaded, whatever. So my point is there are still aspects to be resolved. And I believe that the replacement is a strong term. I think they can be supplementary, complementary. They can be substitutes to a limited extent, but they cannot fully replace physical hearings. That is where I stand on the broad topic for today. Where the problem arises in terms of the legal framework that Vyapak, I completely agree with him to that extent that there is no bar per se, which exists as an impediment in online or virtual hearings. But then again, party autonomy is a double-edged sword. And while everything works on agreement, once a dispute happens, and Vyapak would testify, nothing works after that, right? We're all good friends till the time we're investing in each other's businesses, but the day we decide to have a dispute between us, we will no longer agree on the most silly of things, even if they make sense. So the first impediment will come from the arbitration agreement itself. Did parties contemplate this? If not, the tribunal the parties can then subsequently agree. If they don't, the tribunal steps in as a matter of procedure. And that's where I think it becomes an even bigger challenge. At what point does the tribunal take on the mantle of putting parties in a spot where they don't want to be? Now, I just like to distinguish between two aspects. One, either as a counsel for one of the parties, I would advise my party, if you want a resolution, if you want quick resolution, go ahead and agree to the virtual hearing. Some other counsel or the party themselves might turn around and say, no, I actually want to delay. I don't want the virtual hearing. Let this pandemic be over and I'll come back and discuss it then. You see, whenever you give parties the leeway to subsequently agree on things after the dispute has arisen, the practice or the experience has been that parties will never see eye to eye on anything unless it makes commercial sense to be over with it soon enough. And sadly, and I don't know where Vyapak stands in this, but sadly in India, the experience has not been very, very great. I mean, we've had our share of good decisions and good arbitrations, and when parties have been acted reasonably. But most often than not, from what we see in litigation practice of arbitration, is that parties will challenge almost anything just to gain time or just to harass, just to seek a settlement. Now, in this context is where the problem lies. How do you reconcile efficiency with due process? And to quote, I forget the name, but to quote some famous line which said, one man's delay is another man's due process. right? If I as a party am not agreeing to a virtual hearing, can the tribunal really tell me to do it? And then will that violate my right of fair and equitable treatment, my right of adequate opportunity of presenting my case? And if you look at the English Arbitration Act, Section 33, it says, treat the parties fairly and impartially. And how do you reconcile efficiency and due process concerns? And then later on, would the tribunal really risk the award being challenged on the ground that the party was forced to appear in a virtual hearing when the party had clearly objected? So even though there is no broad objection in the general framework, parties may, as a matter of strategic advantage or tactic, oppose these things. And therefore, the same party autonomy which empowers online hearings suddenly becomes the impediment. The second aspect is seat versus venue. And I think Vyapak is spot on there that seat was always meant to be a fiction, right? The seat is nothing but a connection with the courts of a particular jurisdiction. So no matter where you are in terms of your location, you can go ahead and carry on the arbitration. I think what virtual hearings have done instead is that the venue will now become more important, because wherever you are located, that will give rise to data protection rules, that will give rise to other concerns in terms of what platform, what confidentiality concerns, which jurisdiction you are in, is there a public policy problem there, right? So I think that the seat was always meant to be a fiction and it continues to be a legal fiction. But I think venue, because of virtual hearings, is going to change. So just to sum up in 2 points, that's where I broadly stand in the sense that, before we can go ahead and say, yes, virtual hearings are the way to go ahead. And in this context, just to bring the debate slightly back in, I think there's a 2013 judgment of Praful Desai of the Supreme Court, where the court says virtual hearings are perfectly all right. And I think there are one Delhi High Court and Karnataka High Court judgment, which also permit cross-examination in virtual hearings. So it's not that the judiciary in India is primarily opposed to it, right? But then you come back to the recent judgment of the Supreme Court in the guidelines that they had given in light of the COVID. And I think Para 6 says that you cannot have cross-examination in a virtual setting. So, the legal impediments are being worked out. It's not a done deal yet. And that's why I stand in a slight apparent opposition to the present motion.
Thank you, Ajar, for narrowing down the debate for us. So it seems that both sides at the moment are ad idem on that virtual hearings will find their place. One of them is in the present, and I guess the other one is waiting for a better future. But Ajar, you've raised an important point, and this is where I think I'll have to go back to Mr. Desai on this. Mr. Desai, when we were talking about party autonomy, you mentioned that it's all about flexibility, and there is no reason why both parties will not agree to having virtual hearings. But your co-panelist Ajar presents a contrary view and says that if it's in the interest of the party to delay, then why should you agree? And can really the tribunal decide this issue and risk a challenge to their own award? What would be your viewpoint on this?
Sure. I think with the statement which Ajar has made, looks like there is no debate. I have already possibly won the debate with his first statement. But that's fine. We can still continue to have that discussion, whether even from a timing perspective, whether it is now or later. But on a more serious note, I think most of the arguments which Ajar is making is in the context of the decision that arbitrator or the tribunal or in the institutional rules prescribe for the flexibility of virtual hearings and whether a party can object to it. And if I summarize that, it all goes into the aspect of due process and whether fair and equitable treatment has been given to both the parties by the tribunal. In my view, the concept of due process has gone too far. And we have seen the pitfalls of that with 30 million cases pending in Indian courts, one of the reasons possibly with the backlog. And we have seen from there and now what has happened is even for, I think, few days back, we have seen, courts even saying that, WhatsApp services or social media services for motions or for suits or some applications are also okay, so long as, there is proof of some delivery. I think from a physical systems under CPC for service of motions to social media service of motions, I think we have come a long way when it comes to due process. And it's only a matter of time when an opportunity given with, of course, certain do's and don'ts vis-a-vis virtual hearings. I do not see that when such awards are challenged later, when respondents are not adhering to it or are not comfortable with it or are not supporting it just to delay, would not be overruled when they try and raise the issue of due process when awards are passed, assuming they are passed against the respondents who wanted to delay. So I frankly do not see that as an impediment. Yes, as I raised the point, that it is at the end of the day, even the procedures prescribed for running an arbitration is by agreement of parties. Even under our law, section 19 specifically talks about it. There is an element, but then there are many other provisions under our law which requires express or implied consent of parties, and it has been optimum number of times interpreted that what is an expressed or implied consent. If required, I'm sure it can be incorporated even at the time of entering into an agreement rather than waiting for the dispute to occur. We have seen several innovations in an arbitration agreement vis-a-vis section 9 or section 17, or even in respect to other aspect of the Arbitration Act which requires uh, express or implied consent of the parties to be included as part of the arbitration rules. I really don't see that to be an impediment. Maybe today somebody may want to delay using the reasons of COVID or coronavirus because of the inconvenience cost. But as things progress, I don't see that coming to rescue of a respondent or a recalcitrant respondent, for the simple reason that they even tried when there were physical hearings. They would say, look, we will not come to Bombay, look, we don't have time, look, our counsel is in high court. They would come up with 100 different arguments to not participate in a hearing, and arbitrators have taken care of those situations, and virtual hearing is no different than that inconvenience which a respondent would go through because of a reason for adjournment that they are seeking. So I frankly don't see this any different from an adjournment application or a delay application on part of respondent, which arbitral tribunal can easily go through. And any due process paranoia can can be taken care of as part of the procedural timetable which arbitrator fixes. So in my view, it's to stretch an argument to say that this a respondent who wants to delay can really make things difficult for a long period of time. Maybe COVID is one aspect of it, but you keep COVID aside, there is very little that respondent can say for not participating in virtual hearing, or for arbitrator to follow the due process or give fair chance of appearance to both the parties.
Thank you, Mr. Desai. So sum and substance of your response is that you don't see it as an impediment, and that even if a party is to object, reason may not hold after a point of time. And ultimately, when this issue has to go before the High Court or the superior courts in terms of a challenge, then literally due process will have to be seen whether the reason given by the party to not appear was it justified in light of the surrounding facts and circumstances. In this, or do you have a different take on this point before I conclude this segment of the topic?
Yeah, very quickly. I think, I mean, Vyapak's absolutely right that we've made a big leap. But call me a cynic, but I think that you've allowed WhatsApp service, but I don't know how it's going to play out. For example, if I send summons to Rohan today over WhatsApp, and I want to say that A, that WhatsApp number does not belong to me. B, that phone was not in my hand. B, my WhatsApp number is something, but my actual number is something. Every single solution that you find, there are people who are creative enough to find problems with it. But my point to respond to Vyapak is that when I say delay, I don't only mean deliberate or recalcitrant delay. What I mean is that, let's say, for example, I'm 73 years old, I'm a witness, or the party is not very tech savvy, located in a place with not adequate infrastructure or an IT team. I don't have 360 viewing cameras, or just the cost of data protection compliance or IT implementation is going to be tremendous, or my claim is not that great or not that big for me to go ahead. And at that point, obviously, and it's going to be subjective. It's depending on each fact and circumstance that the due process will be checked by courts. But, again, and just for the sake of this motion, I don't believe that due process is a paranoia. I think due process is the most fundamental aspect of our litigating lives, because without due process, one can do whatever they want. And if the tribunal, let's assume, is extremely tech savvy, but one of the parties is not, then I think one of the obligations that the model law or the arbitration institutional rules envisage is the question of fair and equitable treatment of each person, taking into consideration where they come from. So even though I might not be deliberately delaying, but I may have well-founded reasons to object. Again, and it'll become a cultural and jurisdictional issue as to whether that would stand. But again, in the Indian context, he's absolutely right in the sense that there has been excessive delay on account of due process. Well, let's not get into why the CPC has failed to address that. But and there have been judgments by the courts as well where they have said that you can't raise any frivolous objection. But then again, you have court judgments which actually have gone ahead and supported challenges and sent back awards and sent back applications to the tribunals saying that you did not follow due process. So it just jumping onto virtual hearings with the support of an arbitration agreement and rules, I don't think is enough. It also has to be a change in mindset, and which he rightly pointed out is changing. But again, my point is, we're not there yet.
So one last line, and then maybe, Rohan, we should move on to the next theme. But I think the point made by Rohan was on tech-savvy party. And let me put it very simply, that if a three-wheeler auto rickshaw driver or a Kalipili taxi driver or a Kirana store can be tech-savvy in the remotest part of the country, a party who has entered into a commercial contract, because we are talking about arbitration, which is pure commercial dispute, to expect that they are less tech savvy, I think it's again a stretch. And yes, it requires some support, but with the advancement of technology, I really don't see a problem. But I think I leave it this topic at this level, and then maybe we can move on to the next theme.
Thank you, Mr. Desai. So what we've learned or gathered so far is that today the debate lies in a very narrow compass. And we do see in the future, and at least in the presently, that we are going to move towards more and more of remote hearings. And in that, the first issue perhaps which will be of party autonomy, which Mr. Desai feels is not a big issue. Even a Kirana store or a Kali Pili taxi, if they can understand technology, why can't commercial parties be as tech savvy? And on the other hand, we have Ajar. It's not that easy. It's not that black and white. It's an issue which dovetails into the case. Last but not least, both parties are ad idem on a seat being delinked with having virtual hearings. And perhaps, as Ajar pointed out, the more important issue which will arise in the future would be of the venue and what all regulations for data security and public policy arise in that venue. With this, I think it's time to move on to the second segment, which is about substituting cross-examination in terms of physical hearings to remote hearing. And Ajar, I would like to pick your brains on this segment first. You spoke about party not having a equal and fair opportunity to present their case. How would that issue plan out when it comes to eliciting what you want for your client through a cross-examination, and whether it's doable at all in terms of a remote hearing?
Just to put a bit of context in that, I think the way the debate is centered is, obviously everybody wants efficiency, everybody wants arbitrations to go virtual and all of that. But is it possible? Yes, certainly is it possible. But I think the bigger question is it effective or as effective as a physical cross-examination or eliciting information from a witness? So I'm just going to take a step back, Rohan, and address the point of what we want from a cross-examination. So in a cross-examination, you are putting somebody on the stand to check either of two things. Either you want to discredit the person who has given the testimony or the evidence, or what we in CPC terms call the affidavit in chief, or we want to discredit the testimony itself. Now, in arbitration, and following Vyapak's example of a Kali Pili taxi, is that in commercial disputes, it's not the same way as a criminal dispute. Not much is going to turn on the credibility of the witness or the testimony, because mostly it is document driven, right? But then again, there are commercial complex disputes. Not everything is as black and white. There are construction disputes. There are questions of, the whole purpose of cross-examination stems from either testing knowledge or negligence. And in a certain commercial sense, and I'm giving a very limited example here. Obviously, there are myriads of things that can be discussed. But in a commercial or let's say a bridge dispute or a construction dispute, where there are multiple parties or you have to examine witnesses, you would want a lot of back and forth in terms of the document. I would want Rohan to look at Exhibit A, tell me from the third line, is this what he said or not? Is the signature on Exhibit B his or not? And in a remote hearing, how effectively one is able to do that, I think is going to be a challenge. And why I think it's a challenge is because if you, I think there was a 2014 German study which discussed how perceptions change when things move from a physical space to an online space. And even a 1.2 second delay in response was considered to be affecting the decision of the adjudicators negatively, right? Or tech issues were considered negatively. And I think this example is taken over and over again when remote hearings are discussed. What if you're in the middle of key testimony and whenever you ask an uncomfortable question to a witness and suddenly the internet goes off or the laptop crashes or something? How are adjudicators supposed to assess that? Was it deliberate? Was it not deliberate? How do you go on from there? Then you have these concerns of witness coaching and all of that. And I'll come to that later after, Vyapak has given his thoughts on the issue. But as an advocate, I think there are three primary parts of oral advocacy which hinge on how somebody deals with the case. And one obviously is what we call the opening. The second is cross-examination, and the third is the real arguments, the oral hearing that happens and how you close. And in an online space, the first thing when we are in law school, we are taught as a muti, as maintain eye contact with the tribunal, maintain eye contact with the judge. And I'm staring at a screen looking at both of you, and I don't know whose eye contact am I supposed to maintain. And similarly, when we're examining witnesses, how do you check for demeanor? How do you check for body language? I mean, there are protocols that answer the question. There's a COL protocol which talks about the witness being on an empty desk with their hands visible or standing or using a 360 camera, but it's not the real deal, right? And just to anticipate what Vyapak might want to cover, and maybe he can respond to that, is that it lowers the pressure on the witness as opposed to a physical hearing. And there are often times when cross-examination is more misused. I mean, there are clients the lawyers who want to impress clients by badgering witnesses just to show that they've had their day with the witness or in court. And online hearings tend to give more space and time for the witness to respond and not be under that kind of pressure. But tell me, if the three of us were arbitrators and a witness cross-examination is going on, how much of body language can we judge? How much of demeanor can we judge? And how do you ensure that nobody is being coached? How many screens do you check? What if there is WhatsApp coaching going on? It comes with its own challenges. And I think that's why the Supreme Court also said that unless the High Court issue guidelines with respect to cross-examination, virtual hearings or virtual cross-examinations have to be circumspect in that sense. So, I mean, it's possible, certainly. And I know of three in my own experience where tribunals have taken virtual hearings and virtual cross-examination. But again, it's not a ready-made tailored suit, I mean, that can fit everyone. It has to be on a more fact-based assessment as to, in a particular dispute case, is it possible and how much will it be effective in actually discrediting the witness or the testimony.
Sure.
Thank you, Ajar, for that. And if I broadly understand what you said, you're not saying that cross-examination is required in every arbitration, because in commercial arbitrations, most of the documents speak for themselves. So today you are only confined to those arbitrations where you feel as an advocate that there is a need for cross-examination. And in that select cases, you are of course talking about the efficacy of having remote hearings, and you had highlighted a couple of challenges. Now, Mr. Desai, I would want you to, of course, respond to this efficacy argument. Sure. But at the same time, I felt that this is more of a perspective from an advocate side. Can you also please elucidate what would be the perspective like from the arbitrator's perspective also, when they are supposed to see the credibility of the witness?
Sure. So I think, again, my first reaction to Ajar's argument is they are all, not relevant in the context, at least for an arbitration, for several reasons. First, as he rightly agreed, that most of the arbitration and commercial disputes are purely based on documents. While we advocates love to hold cross-examinations for days together for various reasons, and sometimes only to fill in the days. But frankly, I have seen several days of cross-examination and hundreds of questions and answers not even referred once except in the procedural timetable of an award. And arbitrator tribunal says, look, the issue was the clause on the agreement and all of this is not necessary and the interpretation is very clear, and therefore I come to this conclusion. And so I think the importance of cross-examination, particularly in a commercial dispute, is highly, I would overly stated than what it is. So I think that's my first argument. Having said that, yes, you require cross-examination in many, many cases. And sometimes you have to elucidate certain information where, there are issues about contract enforcement or, agreeing to certain things which are not written down, or actions of the parties and so on and so forth. So yes, there are very, very few of those situations where you really need the cross-examination to go on. Then comes the issue of, let me first take the arbitrator's perspective, because that's what you asked me at the last, but let me take that as first. I think that, again, in my view, is overstated. Even in a very, very complex trials in courts, uh, you know, the case file goes through 10 different judges before it comes to final hearing. And maybe the 11th judge gives the, judgment and the decree. I don't know whether that 11th judge takes note of any credibility, demeanor of the witness while the cross-examination is going on. There are several times that in a court settings, there are 2 or 3 or 4 cross-examinations going on at the same time. And the witnesses are at least 10, 12, 15 feet away from both the lawyers and the judge. So I don't know if that is something which really affects the final judgment uh, in that scenario. And therefore, for the arbitrator's purpose, at the end of the day, it is what is written, and then what comes out. Even if the witness says something wrong which is not part of the document, uh, arbitrator can always ignore, because the document speaks for itself. On the credibility, I think eye contact, demeanor, body language, uh, as I said, even in an arbitration setting, when people are on a same table, the cross examiner and the witness is at least 6-10 feet away on the other side of the table, sometimes around several people. You don't have the right view. Uh, uh, Compared to what we do in a virtual hearing, I can actually see the eyeballs rolling when I speak for Ajar, and he nods that, okay, my argument is demolished. I can see the eyebrows going up and down. Possibly I cannot see that in a physical hearing as well. So I think from a demeanor, eye contact, or a body language part, I can actually see. And in fact, more importantly, I can record it and easily transcribe it easily, and actually re-see and rewind it if arbitrator wants to do that at the time of the award, which sometimes in a physical setting is difficult, because then you cannot record it in that form and fashion the way it gets recorded in a virtual platform. The third part is, today most of the arbitrations are held using video conference platforms. I think uh, very soon we will see integrated platforms for hearings which are suited for hearings, rather than video conferences which are suited for discussions. Like, Zoom meeting is very different than a Zoom webinar. Same thing, there would be a Zoom hearing, because you need a very different platform to support a hearing, right? And it's not so difficult that we are looking at 5 years for that technology to come. And with 3D holographic video calling facilities announced 3 days back by an Indian company, I think some of these aspects can easily be taken care of much sooner than later. So again, I don't see that being any disadvantage for running a cross examination with many institutions, including SIAC and some Canadian and other institutions coming up with virtual hearing integrated platforms. All of this can be taken care of, including recording the witness hearings. And the last point, whether he or she as a witness is coached, you don't have a 360-degree view, whether he or she is looking at the WhatsApp or responses. I think, again, these are all issues which can easily be taken care of, right? Uh, there can always be additional people sitting in the same room, even from the other side, so that it's not that the person sitting as a witness is completely alone, or completely not under anybody's supervision. So that, in my view, with or without technology, can be taken care of most conveniently, and it's not a hurdle to even talk about. And in terms of coaching, if I see somebody looking below or on the side all the time, I think that in itself is a demeanor issue or a body language issue. and which can be seen easily, through in a virtual hearing, can be recorded for future reference. So again, what we are talking about here is a change in the manner and the advocacy skills that may be required for such a disruption to happen, because we are used to physical files and we are used to asking questions and looking at the witness and trying to do the theatrics. Maybe that advocacy skill was good in the 18th and the 19th century, but I think time has come to even disrupt the advocacy skills. And I'm sure we will develop new skills and better efficiency as part of this system. And that's what has happened in every other industry, as I started with. And in my view, this industry, if I call it as an industry from a judicial system perspective, I think it's high time that we imbibe technology for a better, efficient process. And even small advancement in those situations, we have seen how good it has effectively worked, even in a court setting where today you can see on internet which matter is going on in Delhi High Court or Bombay High Court. Earlier people used to not be comfortable with that. People used to want to hear what physically things are happening in a court, right? So I think things have changed. Technology has helped the case management system, and advocacy skills have to be relearned and unlearned in that sense, for an effective dispute resolution, because at the end of the day, that's what the dispute resolution is for.
Thank you, Mr. Desai. And I will quickly come to you, Ajar. But just to summarize, I think the efficacy argument has been responded by Mr. Desai in three parts. One, by saying the concerns regarding cross-examination and demeanor, etc., are slightly overstated. In any case, point number two, they can be solved by technology. There is 3D holographic technology already coming in. And lastly, even without technology, these concerns can be addressed by managing the logistics. I'm sure you have something to say on this, but where I would like to really focus you on is the last issue that Mr. Desai raised, where he's actually propagating a change not only in the mindset, but also in the way we actually conduct oral advocacy, but more importantly, how we conduct cross-examination. So can I quickly have your view on that before we move on to the next segment?
Yeah, sure. Rohan, I'll be as candid in that I am a great advocate of suggesting that there is a huge change in advocacy required. There is a huge change in the way we approach arbitration in India that is required. In fact, I've written a piece, if I remember, on the Bhopal NLRU blog about how cross-examinations are conducted terribly in Indian arbitration, and they lose their purpose, and they're just, like he suggested, we simply fill in days just to go on and on. So I agree that there is a change in advocacy style required, but then how you can't, I mean, to simply just to get back at what Vyapak was trying to address, he said that the 11th judge will pass the order and the cross-examination will never be looked at. I would say that that's too simplistic a view, because that impliedly suggests that cross-examination is irrelevant in commercial disputes, at which point I would beg to differ from him. Also, the fact that all institutions and rules and laws recognize cross-examination as a great tool. I remember in second year of law school, I remember a judgment where the judge observed that the witness kept shaking his legs and his fingers were trembling, and he was visibly nervous. And that led to the judge questioning the credibility of the witness. Now, as much as humorously Vyapak can see my eyeballs rolling and assume that his arguments have demolished mine, I don't think he can see if I'm nervous. I don't think he can see whether I'm shaking my leg. And you know, again, just to put it out there, I'm not suggesting that we should shun virtual hearings or we should not adopt them. I'm simply saying that they have limitations. And yes, one way is to have one person in the other room, but that might not always be possible. That might not always be effective. That might not always be logistically or in a COVID situation, in a lockdown, permissible, right? So all I'm trying to get at is that there are a certain amount of challenges, and as tribunals go on pursuing them, they have to identify those challenges as part of procedure, as part of possible challenge points later on when the award is being challenged on those grounds. And just one last point that I would want to add I completely echo Vyapak's opinion on the oral advocacy and the change in advocacy that we require, because I personally think we are very common law driven, and in arbitration that is not always the best case. But again, I think that cross-examination does serve an effective purpose, because if I'm examining a witness who can tell me in let's say an hour's time, or I can elicit information which can elicit to the tribunal as to whether there was a defect in the bridge I had built, or let's say the DLF mall, the roof that collapsed, was it negligence or not, and I want an expert to review the situation. I think it serves a purpose, and if it serves a purpose, then we need to rethink our entire philosophy of how we approach testimony and evidence in order to assess the truth. And I know that civil law is very different. Prague rules envisage a very different scenario where the arbitrators can actually pursue civil law remedies in terms of actually going and visiting the site and things like that. So, I mean, there are cultural differences in cross-examination as well. And I would leave you with the statement that arbitration is cross-jurisdictional, and I think cross-examination is very jurisdiction specific in as to where you're coming from. And therefore, yes, changes are required, but then again, there has to be procedurally aligned with the background of the parties.
Thank you, Ajar, for that. And at least this segment I would like to conclude so that we can move on to the next section on final hearing, and perhaps any comments that Mr. Desai have on cross-examination, he can address it while they're talking about final arguments, because generally the concern seems to be more about adapting to technology, and the challenges more or less appear to be the same, except on the demeanor part.
Yeah,
now,
so only one point and we can move on is, I think I'm not saying that cross-examination is not relevant when there are, different judges looking at a case. What I was saying is that, even in civil suits, commissions are appointed to take cross-examination while judge decides, on merits, and the case file goes from one to another. So from a credibility of witness, which judge looks at it and who finally passes the final judgment is not always the same person. While in a video recording kind of a situation, you can actually look at those even at the later stage. And therefore, if that was important, it is easily done in a case where it is virtual hearing and easily transcribed or recorded, if at all it is necessary. Because even in civil cases, right, most of the cases go to commissions for recording of cross-examination, and nobody writes about credibility there. They only record questions and answers. So what I was saying is that aspect is relevant, but overstated, and in fact can be an opportunity of looking at those aspects better in a virtual setting than a physical hearing. So that was the short point, but we can move on to the next.
Thank you, Mr. Desai. And the last segment is about final arguments. And practically the challenge that we face is the way we conduct final arguments. There's a counsel who's arguing the matter, but he's assisted by a small battalion and army who are passing on pages to cite, paragraphs to read out, judgments to perhaps quote and read out. How do you see, Mr. Desai, this being panned out during the course of arguments? And maybe your own personal experience can come into play.
Sure. So I think we are already 1 hour, so I'll keep this segment very quick and short. I just want to put 2 points on this. One is, how do you manage, quick references, support from your team while arguments, put those judgments? I think that can be again solved only by doing two simple things. I think we need to be more prepared than what we are used to in today's situation. We go pretty unprepared while we do our arguments before a tribunal. We don't think about the judgments. We don't give those judgments in advance. We don't put our arguments in writing or do opening submissions. So I think the first point is preparation. Simple. That will take care of 80% of the things that the senior advocates while arguing don't have handy, and they need support from, because they simply go and argue without preparations. Two, having team on your side. I think that again is a COVID issue. Today you are able, not everyone needs to be at different place all the time. A virtual hearing doesn't mean everyone is in a different room. A virtual hearing only means that everyone need not be in the same room. So I think we need to differentiate between these two. And if you need any support, somebody can always sit on your side to help you. Yes, first 2 months of COVID, that was a little difficult because of the lockdown. But even today, if you need one or two people on your side, where arbitrator is sitting in Singapore or in Delhi and I am in Bombay, nobody stops you from doing that. So I think uh, both of this can be easily taken care of by two simple things. Uh, Unfortunately, you have to be better prepared than what you are today. And two, have anybody on your side, no problem, for any help that you need. But to insist everyone to come into the same room, that is what is not required.
I think, Ajar, those points were quite clear. And without wasting any time, I would like you to respond to those points and maybe what you have in mind.
I actually, the way this discussion is structured, it sort of appears that I'm opposing Vyapak on points, whereas in fact I am in quite an agreement with the thing. But just because it is structured like a debate, I have 2 points on that, and one is that in any international arbitration, at least not many in India, usually we are required to submit written submissions or at least skeletal arguments way before the actual final oral hearing happens. And therefore, any right fair tribunal they would have digested those materials before the concluding arguments are made. Therefore, there is little, I wouldn't say there's little, but there is only so much that you add in terms of a final hearing. Because again, like it's document driven, the tribunal is going to read it. You have written submissions, the exhibits have been flagged. The witness testimony, like Vyapak said, would have been recorded, transcribed, and flagged, and the tribunal secretaries would do a fantastic job of that. But then again, as a counsel, I think it still matters, because there are those open and shut cases where you read the documents and you're convinced one way. But I think from our courtroom practice and even from some tribunal practice, you would agree that the way the counsel presents the evidence at the end in a holistic manner sometimes tends to sway judges or arbitrators, or at least create an iota of doubt. And that is an effective tool in terms of culminating the dispute. And while it is true that you don't always need people assisting you and we can all be very well prepared, but imagine the claim that the Boeing aircrafts would result in, the multiple claims, the multiple nuances, the multiple exhibits, and as well prepared as we might be, we would still need some sort of assistance. And one solution obviously is if Vyapak is in his law firm office, or if I'm in my law firm office and I have my associates with me, or he has his, we can all go along, and that's fine. But in terms of the efficacy or the effectiveness of when I'm presenting, then I'm stopping, and in a physical hearing, nobody minds that. But psychologically, in a virtual hearing, like I said, even a small pause can be considered as being hesitant or not being entirely convincing. And my personal take on that is that you can be effective. It's not that you cannot be. But I think, again, and I think this goes to his point of disruption and advocacy, is that we need to gear ourselves a lot more before we can actually come back satisfied as to I had my day in court or I had my day before the tribunal and I argued very effectively. And even though the tribunal was 50-50, I think I have them where I want them. And to that extent, I think technology would serve as a slight limitation, especially if you're a senior. I mean, if you've seen any of those senior arbitrators like Mr. Bond or anyone else in a hearing, what actually happens is that he's briefed 2 days or 1 day before a big investment claim, and possibly he possibly could not have gone through all of it together. And now, if due to COVID, any of those senior arbitrators are being forced to be all alone, I think it would become a challenge for anybody, no matter how brilliant they are, to actually effectively deliver on the oral presentation. And just to tie to that point, I think Section 24 of our Arbitration Act talks about the right to an oral hearing, but again does not clarify whether it has to be physical or virtual. So in that sense, I don't know how procedurally we would stand. But again, point Vyapak made was well taken, that we need to be more prepared and think about arbitration or virtual hearings in a slightly different manner as that we've been approaching so far.
So at least on this segment, I'm happy to say that we are closer to each other than we were on the other segments. And I think preparation is key. And perhaps the flair of advocacy, which Ajar pointed out, that might have to be done in a different way while adapting to this new way of arguing. I think we've overshot our time, but I would still like to give our panelists 2 minutes each at least to summarize their position on all these 3 segments or themes that we've discussed, starting with our panelist against the motion who's not so against the motion. And I will leave you to start the summary.
Yeah, well, thank you for clearing that up, Rohan. I'm not so against the motion. I'm just against the word replacement, right? I'm on the point of not just yet. Again, I would just summarize saying that there are still due process concerns when it comes to virtual hearings. As much as we would like to believe that commercial parties are extremely sophisticated and have the financial bandwidth and the means to participate in virtual hearings, I think that there are still lots of bridges that we need to cross. For example, simply if I were to take the power corporation of any state to a virtual hearing tomorrow, and they have to set up an IT facility or a virtual conference room for it, if they don't have one, there are so many government approvals that are required, X, Y, Z. I mean, you're getting my point. Yes, everybody's using WhatsApp today, everybody's on Skype. We all are talking about Zoom and other things. But how comfortable are we as an ecosystem in terms of all judges, lawyers, everyone? I think there is still some gaps there. Also, it's a legal debate, and I don't want to bring too much of psychology into it. But I think that in an online space, everybody's a bit more conscious. Even arbitrators would, and especially if it's being recorded, arbitrators would hesitate, and so would lawyers. And I know, and it goes back to his point of let's not be as aggressive or as hard grilling of witnesses. But then again, I think they do serve a purpose, right? And sometimes they work as effective tools as well. So to sum up my position, it is that yes, virtual hearings can replace physical hearings after we've taken care of due process concerns and limitations that may arise out of technologies, and when the mindset of everybody in the ecosystem is as supportive as Vyapak is hopeful it is.
Sure. I think as I stated in the beginning, I think the good part of this debate is that we both are on the same side, so I don't have to win anything. But unfortunately, none of us have the right to change the topic for the debate. So that is not in the hands of Ajar. But coming to the issue here, and since it's a summary of what we have been talking about, I think whenever, as I started saying, right, things are not changing, things are getting disrupted. So obviously, disruption would be much faster than the support system it develops around it. And we just have to find our way to support that disruption. But I think it is also something that we are, looking at it from a perspective that, okay, people are not ready, things are not ready. I think we are underestimating the adaptability and the technology advancement which is happening at a rapid pace. Uh, Earlier, it used to take 10, 20, 30 years for a new technology to get adopted, whether it was television or telephone, or even basic change from messaging to fax messaging or whatever. Now that thing has changed from 10, 20, 30 years to few months for people to adapt. So I think while it may sound that we are yet not ready, in my view, the time that we will get ready would be much quicker than people anticipate. So better embrace it rather than run away from it. And two, I think it's time that we find alternatives for a better dispute resolution system, which is faster, quicker, speedier, cost efficient, with whatever limitations it comes with it at this stage, which if technology can answer, well and good. If people can adapt, well and good. But one way or the other will overcome. So that's what my sense is. There are no legal or practical impediments to adopt this as a way forward.
Thank you, Mr. Desai, and thank you, Mr. Rav, for that lovely, exciting debate. The best part was that I got to see both of you and your demeanors while you were responding to each other. So the silver lining is that some kind of demeanor readment is possible. And at least my takeaway as a moderator is that yes, we are all in agreement that today there is no legal impediment, and that's a green signal for us. But that has taken right to three issues. One is that of mindset, and that's what I saw with Mr. Desai. He seems to be the kind of person who looks at the silver lining in the dark clouds. He welcomes disruption and finds that as a new way to turn over a new leaf. But at the same time, I do see some sense in Ajar being guarded about such a change happening at a drastic pace without identifying the challenges, whether those challenges are up in the mind or are actually there in reality. And number two, it is an issue of timing. We have already started our way onto the shift towards online hearing, but yes, there are certain challenges regarding witness coaching, how we need to manage logistics, how team needs to be more cohesive and coordinate with each other. And that is the difference between where we are today and where we need to go in the future. And with that, I think the only last thing I would like to end this debate is that the only constant is a change, and that we must do not only with the technology, but also upskill ourselves as lawyers as we need to adapt to this new mode, this new normal. And it was wonderful being a moderator, and I thoroughly enjoyed your discussion. And now, with everybody's permission, I would like to open the floor for question and answers from the audience. Nitya, you have to unmute yourself.
Yeah. Yes, sir. I have sent you the questions that the participants have asked. You can direct them to the speaker.
Okay, great. We have a few interesting questions, and because of paucity of time, I will try and take 2 questions, one for each panelist. So the first question, I think for this can be for Ajar, is that considering virtual arbitrations today are conducted through web platforms, are these platforms bound under the oath or duty of confidentiality? And because you did raise that issue, I think Ajar, you would be fit to answer this as well.
Well, yes, they are, and the extent then becomes subject to applicable law in the jurisdiction where this is happening. And this goes back to the point that I was trying to make regarding the venue. So we are on the Zoom platform. Vyapak's in Mumbai. I'm in Delhi. Rohan's in Delhi. But Zoom, is it located in India or the United States? What are the data protection laws? What if we have somebody in the EU and the GDPR applies? I mean, those are questions that platforms, arbitrators, tribunals, everybody will have to now deal with as to where, and do they drastically change the outcome of arbitration or arbitral proceedings? And yes, confidentiality is an issue, because if I have an IT specialist in the room, simply to ensure that everything goes on time, do I have an NDA with him? Do I have a confidentiality agreement with him? Who is providing that IT support? Is it in-house? Is it being sourced from a third party? I think those are the kind of challenges that we still need to address, just the fine tuning before we address them. But yes, upfront, there has to be some sort of confidentiality in the platforms or the web platforms being used. And it cannot just simply, you can't choose any platform and go ahead with it. And I think that's a bit of a diligence that I think primarily the tribunal will have to undertake as well as the parties.
Sure. Just to add here, Rohan, in fact, this issue has been identified internationally, as rightly pointed out by Ajar, particularly in the context of GDPR and other data protection laws. In fact, ICA, the ICCA and IBA has already put a joint task force. We actually had a webinar last week where I participated, that they are coming up with guidelines as to what councils and the tribunal will have to follow in terms of disclosures and records to comply with some of those data protection laws. So I think the work is already at a very late stage, and there will be enough guidance internationally and domestically to take care of data protection issues. Two, in terms of platforms, as I said, we need to move away from just video conferences, platform to virtual hearing integrated platforms, which would be much more secured, and there will be enough checks and balances to maintain data protection and confidentiality. And the third one, there will be several third parties involved in the system of setting up the virtual hearing. But today, a lot of hearings happen in a hotel, where business center, gets an email to print some documents, and it goes from X to Y, and we actually don't know what happens to confidentiality. I was just telling someone in another webinar that, right at the start or right at the entrance of the hotel, actually there is a big board, arbitration proceedings, so and so versus so and so, and they put it because of their simple protocol or processes. But what happens to confidentiality right from there to the business center printing to room service, whatever XYZ, and people floating around during the arbitration. So obviously physical hearings have the different issues related to confidentiality. Virtual hearings will have a different issue because of third party involved, but there are actual committees and joint task force established to take care of these situations, and there will be enough guidance as we go along.
Thank you, Mr. Desai. And I will roll up 2 questions into one for you, Mr. Desai, which is that what changes do you anticipate should be made perhaps or should not be made if not required to the Arbitration Act so that we have the right kind of legal framework to handle virtual hearings? And 2, how do we establish or what infrastructure is needed to have like a Maxwell chambers in India across different cities?
I think my theory is we should rely as less as possible for changes in law, because that can always bring in a nuance which you didn't anticipate at the time when the change was being brought. And 2019 amendments are a classic example of that. To do you really need a change for that, or do you need a change in terms of practice? I think we can look at it a little more minutely on this and see whether we frankly need a change so far as law is concerned. My sense is it can be taken care of with the existing law, with little tweaks in the process or procedures or practical implementation of an arbitration. Less said in the law is better so far as India is concerned. And the third aspect is on the setting up of facilities like Maxwell Chambers. I think it's all coming through. It's slow, but it's coming through. We have institutional support coming in Mumbai, Delhi, Chennai. Many institutions are gearing up for both physical and virtual infrastructure. And frankly speaking, with the flexibility of adopting virtual infrastructure, which may not be purely India driven to start with, but adopting it as we go along may be easier to have our own indigenous platform than worrying about a large physical facility to come up and to develop. So whether it is Delhi International Arbitration Center or MCIA in Mumbai or NPSC in Chennai, I think everyone is gearing up to the requirements. So we are very close to what internationally is available. It's only a question of adopting it. And with 2019 amendments ultimately going through, I think institutional support through the law also, taking parties to that route is only going to help the advancement of institutional arbitration.
Thank you for that detailed answer, Mr. Desai. And as a moderator, I should be fair and equitable, and I would not like to close it without giving the final chance to Ajar to say a few words so that we can wrap this session up.
I personally think that Vyapak has put it very, very aptly. And now that the debate is officially over, I may say that Vyapak and I are on the same page. I was told to play the devil's advocate, which I have done for better or worse is a judgment I leave to everybody viewing this. But yes, technology is here. We need to adapt it. I fully agree with him that the lesser is put in Indian law, the better it is. We wanted to recognize arbitral institutes. We wanted to recognize affiliations, and we introduced Schedule 8, which is a wonderful creation, which I don't know what purpose it will serve. But the point is that given, and this is what Vyapak started with, given that there are no straight out prohibitions or barriers in the current legal framework, I think the answer to the question is that no, we don't need an amendment prima facie to implement virtual hearings in this country. And I think that the current framework is sufficient to address it. Again, like I said, I think it's more of a question of adapting to it in the sense of an ecosystem mindset and arbitrators being mindful of their procedural duties in terms of compliance with things like confidentiality, data protection, etc. Especially because we now have arbitrator immunity, which borders on negligence and good faith. So again, fully agree with Vyapak. I have no further comments to add, except that yes, we are on the same page.
Thank you, Ajar. Thank you, Mr. Desai, for that lovely discussion and debate. And with this, I end this debate and I hand over the stage, not really the stage, but the screen to Nithya to officially close the discussion.
Thank you, everyone. It was indeed a wonderful debate, and I'm happy to share. We have had around 250 attendees viewing this debate. Both the speakers were quite candid yet poignant. And Mr. Rohan, you have wonderfully handled the moderation of the session. So this, I announce this as a successful debate, I think. And with that, thank you, everyone. Thank you for joining us. We would also like to thank our media partner, Legal Desire, who have held us in media and technical support, and my team. and all of the speakers and panelists. Thank you very much, everyone.
Thanks a lot for having us here, and thank you everyone to stay on for almost 1.5 hours. And thank you, Nitya and Rohan, for a wonderful debate. Thank you.
Yeah. Thank you, Vyapak. It was great to agree and disagree with you.
Yeah, thank you.
Thank you, Rohan and Nitya.
That made my job very tough.